The next point is that a discredited model still survives. Think of Kate Moss. A discredited model still survives. What does that mean? Once people get their trial story in their mind, they will reject evidence that's inconsistent with it. You bring evidence at that point, if you let them choose the other side's model because you don't have one of your own, and then you discredit the other side's model and you're wondering why they find for the other side anyway, it's because the discredited model can still survive. So evidence received during primacy has an undue influence on the final judgment and on what happens in the jury room. If you want reinforcement, you want to reinforce that model, you try your case in the language of the court's charge. All the way through the case, you're talking about the language that's going to be used in the court's charge. If you're trying a case involving special mission, you should be talking the terminology of special mission throughout the trial. You should be talking about all the language that will go into the definition of special mission throughout the trial. The worst thing that can happen to you is for them to walk into a jury room, they read the charge for the first time, and they hear the term special mission. What's that all about? So you want to try your case in terms of the court's charge because that gives you reinforcement, and it follows right on through with all the way through to deliberations in the jury room. You need to have a synergistic presentation. These things should be in compliance. You should have synergy between your pleadings, your voir dire, your opening, your evidence, your summation, the court's charge, and the final judgment. Those things should all fit together. They should be in the same language. They should all be the very language that you use during the course of the trial. The empathy bias is that empathy, not sympathy. Empathy motivates jurors to help those they perceive as two things, both in need and worthy of their help. Empathy helped elect a president. When Bill Clinton said, "I feel your pain," he reached out to a very, very large contingent of voters in this country who had been ignored and who had had their benefits taken away by a Republican administration. And when he said, "I feel your pain," he was empathizing with them. And empathy resonates, whereas sympathy is demeaning. We're looking for empathy. Empathy creates partiality, and it's easier to empathize with a plaintiff who is not negligent. Another reason why you don't just prove the negligence of the defendant, you prove the absence of negligence of the plaintiff. Jurors who empathize with plaintiffs are less vulnerable to allegations of the plaintiff's negligence. If they truly empathize, they'll overlook the plaintiff's negligence. So the emphasis should be on the plaintiff's absence of negligence, their efforts at rehabilitation. They need to have an improvement plan in place because it goes back to worthy of their help. If you want to get an award of damages, you have to prove that you are worthy of the help of the jurors. Then the jurors look at it and say, if you're not helping yourself, why should we help you? You have to show your efforts at rehabilitation, and you have to have a distinct and firm improvement plan, preferably one that uses the money from the recovery put into evidence. Focus on the courage of the plaintiff, avoid appeals to sympathy, and avoid lawyer tricks at all costs. You have to establish the productive use of a jury award, and always be ready to answer this question because the question will come up in a jury room. What good purpose will be accomplished by a jury award? A death case, they'll say, well, you know, it won't bring the wife back, won't bring the husband back. So you have to have an answer to what good purpose will be served by a jury award in this case. The next is the norm bias. And the norm bias is that causation involves comparing what actually happens to the normal case where the injury does not occur. And again, you do that by showing the normal standard and especially Gen X and Gen Y, are very, very moved by standards. And then you compare the conduct of the defendant to the standard and show that they violated the norm. Jurors, now listen to this, jurors who imagine an alternative scenario that changes some surprising, unusual, or abnormal event will go with the plaintiff. Now what does that mean? You accomplish that by showing that the defendant had choices. Jurors who can imagine an alternative scenario that changes the outcome, same thing, you're showing the outcome is not inevitable. You show the alternatives available to the defendant that would have avoided this tragedy. Jurors who identify with the plaintiff will contemplate how the plaintiff might have acted differently due to defensive attribution. You have to, if you have someone that you're worried about defensive attribution, you have to answer all those questions. You don't leave it for them to think, well, the plaintiff was probably doing this, they were probably doing that, they probably knew. You have to show the plaintiff's precise knowledge, show exactly what the plaintiff was doing, prove that the plaintiff was free of negligence. Jurors who imagine the defendant acting differently are more likely to find causation. What does that say? If you show the jury that the defendant had other choices, they're more likely to find causation. And then under the norm bias, you get to this. This is the availability bias in conjunction with it. The person upon whom attention is focused receives the most criticism. Think about that. With your availability bias now, the person upon whom the most attention is focused will have the most scrutiny of their actions. And they, in the course of the scrutiny of their actions, will receive the most criticism. So in using the availability bias, you want to keep the focus on the egregious conduct of the defendant, on the personality of the defendant, on the creation of the circumstances by the defendant, on the defendant's purposive action, on the plaintiff's reactive outcome, and on the lack of negligence on the part of the plaintiff. Very important point in this whole power of choice thing. The more choices available to the defendant, the more likely jurors will find liability. So when you prove, if you have a product liability case and you're proving a safer alternative design, don't prove one, prove two, prove three, prove four. In a medical negligence case, if you have two choices, the doctor could have done A or B and they chose to do A, and that resulted in the injury to the plaintiff, odds are that's not going to get you there, because the doctor every time will have friends lined up who will come in and testify, well, A is a proper standard, but so is B. And either one would have been a proper choice. So there's no negligence there. In a doctor's case, in malpractice case, you need to show the more choices available to the doctor, the more likely you are to find liability on the defendant doctor or any healthcare provider. The other thing is, the more choices you can show, at some point, an irritation factor kicks in. So if you show that the doctor could have done A, he could have done B, could have done C, could have done D, he chose instead to do E, which was to send the patient home without testing, the more choices you show, the more money the jury will award. The larger awards will follow that because of the irritation factor. Because the doctor chose, he made 4 bad choices. 5 bad choices, really. He chose not to do this test, he chose not to do this one, chose not to do this one, chose not to do this one. He chose instead to do none of them and send the patient home. That's 5 bad choices. That's where you start getting into larger awards because the jury's just mad at the person now. On the causation bias, would the injury have occurred in the absence of defendant's conduct is one way to look at it. That's a sine qua non argument. But in order to answer that question, you show the other conduct that the defendant could have done that would have avoided all this.